Is obscene content protected under free speech laws? Imagine browsing the internet or flipping through a magazine and wondering what kind of sexual content is okay to share or keep. It's a tricky area, and knowing where the line is can be confusing. Today, we're going to clarify whether obscene content falls under free speech protections. In the United States, the First Amendment protects many kinds of speech, but not all. Obscene content is generally not protected. The Supreme Court has made it clear that material considered obscene can be regulated or even criminalized without violating free speech rights. This means the government can restrict or punish the distribution of obscene material. So, what exactly is considered obscene? It's not just any sexual content. Obscenity involves specific legal criteria. It refers to sexually explicit material that appeals to a prurient interest, which means an excessive or shameful focus on sexual matters. It also must be considered offensive by community standards and lack serious value in literature, art, politics, or science. The main test used by courts to decide if something is obscene is called the Miller test. It has 3 parts. First, would the average person, applying current community standards, find that the work appeals to prurient interest? Second, does the work depict or describe sexual conduct in a way that is patently offensive according to law? Third, does the work lack serious literary, artistic, political, or scientific value? If all 3 are true, then the material is legally obscene and not protected by free speech. Laws at both the federal and state levels prohibit the sale, distribution, or transmission of obscene content. Violating these laws can lead to fines or jail time. However, private possession of obscene material usually isn't criminal, but sharing or sending it through mail or online can be illegal. It's important to distinguish obscene content from other types of speech. Indecent material, like nudity or certain language, is usually protected but can be restricted to protect minors. Child pornography is illegal in all cases, no matter what. Other unprotected speech includes threats, defamation, and fighting words. Because community standards can vary from place to place and change over time, what's considered obscene in one area might not be in another. This can be especially tricky today with the internet, where content is accessible worldwide. Courts continue to work on these issues, but the rule remains that obscene content is not protected by free speech laws. Knowing your rights means understanding that free speech does not give you the right to create or share obscene content if it meets the legal definition of obscenity. If you come across or distribute sexual content, be aware that it could be considered obscene and lead to legal trouble. Platforms and social media sites may also restrict such content, as their rules often align with legal standards. In short, while free speech covers many forms of expression, obscene content is a narrow exception. It is not protected under the First Amendment if it meets the legal criteria for obscenity. Understanding these standards helps you stay within the law and avoid unintended consequences when dealing with sexually explicit materials.